Good afternoon, everybody. So because I don't speak French, I hope Pascal said only nice things about me and nothing bad. I'm going to give a presentation touching on the interaction between Global North and Global South actors within the context of the Corporate Sustainability Due Diligence Directive. So I used to be at the University of Luxembourg until very recently. I just moved to Germany a few weeks ago. I'm very happy to be back here today and to have these important discussions with you. So the good thing about going third is that my work has mostly been done by the people who have gone in front of me. But what I'm going to do is I'm going to perhaps highlight certain aspects of the Corporate Sustainability Due Diligence Directive that I refer to as setting up an architecture for potential collaboration between Global North and Global South actors. And then I'll tell you why this is important, that we actually think about ways to keep bridging the gap between Global North and Global South actors if we want mandatory human rights due diligence laws, such as the EU Due Diligence Directive, to have an impact on the ground. So in terms of the presentation itself, I had initially thought that I'd have it divided into 5 parts, but that's too ambitious always. And so I'll divide that into 2, let's say. After this brief introduction, I'll jump straight into the directive itself to pick up certain points of the directive where Global South stakeholders can be involved in the due diligence processes. And then I'll move away from the law and into the practice to highlight what I think are very real barriers that still exist in terms of bringing these directives to life. And then, of course, I'll conclude with room for discussion within the context of a Q&A. So Jean-Louis started by saying that the due diligence directive is a game changer. And I absolutely agree, but I'm a lawyer, so I always have to say it depends, right? It can be a game changer if implementation is done properly. And if you think about having a law on paper, laws on paper don't always transform into laws in reality, right? So we're here in a European country, a very fabulous European country, of course, and we're thinking about a law that could potentially impact the human rights and environments of people in the Global South. And we're saying, oh, this is a great law, it's going to change the realities on the ground. But is it? Is it really going to be a game changer for the very people upon whom we are placing the hopes, of this particular law? I think that even if we think that the CSDDD is a game changer, we cannot lose sight of the fact that there are still very many practical obstacles that have to be surmounted by Global South stakeholders before these laws can actually change their realities. So both within the context of transposition as well as implementation, there are many things that we have to do to try to bridge this gap between the various stakeholders so that the law can actually come to life. So let me highlight a number of provisions of the directive that set up a sort of architecture within which cooperation can occur between stakeholders of the Global North and the Global South. Now, some of them have already been mentioned by Robert McCorkdale and Bashak and Eduardo, so I'm very happy to be coming in last because, like I said, they've done a little bit of the groundwork for me. So, of course, if you've been following the discussions around the CSDDD, you know that in the beginning of the year, it was very tricky. Last year, we left the year thinking, oh, yes, we're going to have a directive, everything is sorted. But in the beginning of the year, there was a little bit of a compromise that had to be reached that resulted into the directive being significantly watered down in terms of the size, in terms of certain other things that have been mentioned. But one good thing, or a couple of good things that found themselves into the final version of the directive include certain provisions that make it possible for Global South stakeholders and other stakeholders to be able to participate in due diligence processes. So first of all, to begin with, Article 3N actually introduce a definition of the term stakeholders, because we keep talking about stakeholders, we keep talking about meaningful stakeholder engagement, but who are these stakeholders? So of course the article tries to set the stage by talking about stakeholders being lots of different parties, right? You're thinking about employees of companies, you're thinking about employees of subsidiaries, employees of business partners, you're thinking about individuals and communities that could be affected by the activities of companies. You're also thinking about the legitimate representatives of these people. Building up on that, we have a provision that almost didn't make it, and it took, the successive versions from the European Commission version to the European Parliament version to this final version that we had to have a standalone provision on meaningful stakeholder engagement, and this is on Article 13. Now, as other speakers before me have mentioned, meaningful stakeholder engagement is an integral part of human rights due diligence, because companies, in trying to implement due diligence, must necessarily consult and engage the very people who are being affected by their activities. So Article 13 sets the stage for meaningful stakeholder engagement. It tells companies, look, you have to give stakeholders information so that they can be able to engage meaningfully. You have to protect stakeholders from retribution, so that people can't be able to fully participate in these due diligence processes. The article even specifies which parts of the due diligence process must be done together with stakeholders. So this is a very important provision in terms of setting the stage for Global South stakeholders, not just to be passive recipients of laws from Europe, but to actually be active participants within the process of trying to ensure responsible business conduct on a global scale. In addition, we have Article 14 that creates both a notification mechanism as well as a complaints mechanism. So this has been mentioned as well. And the thought is that ideally, it should be possible for stakeholders to be able to report potential adverse impacts, and when actual adverse impacts have occurred, to be able to first go to the company and raise a complaint. So this is the operational level grievance mechanism, as has been mentioned. Article 26 talks about substantiated concerns to supervisory authorities. So this has already been mentioned by the other speakers as well, the fact that the EU directive sets up a sort of administrative procedure as well, where you're going to have very specific administrative bodies that are responsible for implementation of the directive. So, for instance, in Germany, which has already had its directive for some time, you have the BAFA, so BAFA, and they've done quite a bit of work already in terms of administrative enforcement of the Lieferkettengesetz. In Norway, you also have a body already that has been doing some work since the Norwegian Act came into law, and that's the Norwegian Consumer Authority. The Dutch are moving quite quickly with transposition. Bashak talked about the fact that in Luxembourg, things take a little bit of time, but if you've been following the discussions, just last week, Netherlands already had their first draft, and it's out and about for consultation. And they have already identified the Dutch Authority for Consumers and Markets as being the supervisory authority. So these supervisory authorities are going to be very important for right holders and for stakeholders, because the hope is, within the context of Article 26, that stakeholders who feel that their rights are potentially or actually violated can actually go to the supervisory authority with substantiated concerns and raise these concerns. And then the authority has certain powers. It can issue fines, it can issue penalties, it can give certain orders to the companies in question. And again, using the example of Germany, because they have had quite an active supervisory authority for the past couple of years, these mechanisms are being used by stakeholders outside of Europe to try and already vindicate their rights. Now, of course, the directive also sets up a regime of civil liability, and this is under Article 29. And of course, civil liability means that there's the chance that stakeholders who have suffered violation, as well as their legitimate representatives, can be able to come to a court in a European country and sue the company, and depending on whether they are able to prove that there was a breach, there was damage, there was causation, they could be able to win the case. It sounds great on paper. It sounds like, wow, this is really a game changer in terms of ensuring responsible business conduct. But the reality is that if you think about transnational litigation, imagine a farmer somewhere in Kenya, where I come from, or imagine a miner somewhere in Ghana, or imagine any other global South worker or stakeholder who wants to make use of this law, who has suffered violations of their human rights and the environment. How easy or difficult, actually, would it be for them to come to Europe, to Luxembourg, bring a case, see the case all the way through to the end, and get victory against a company that is culpable? It's not that simple. simple, right? Which is why I want to emphasize the fact that having a law on paper doesn't always transform to having a law in reality. And perhaps as part of the conversations we're going to continue having today, we have to continue to try and see ways in which we can be able to perhaps ensure that these laws are implemented effectively for their purpose to be achieved. So Article 29 talks about certain things that can be done to make the barriers a little less difficult for stakeholders. It talks about the statute of limitations, for example, that at the very minimum, there should be 5 years for stakeholders to be able to bring claims. It talks about standing. Stakeholders can get representatives such as CSOs based in Europe to help them bring cases. It talks about the fact that proceedings should not be too expensive, right, so that stakeholders are actually able to make use of all of these provisions. So already this part is a little bit redundant because from the discussion that I've had, you can already see some of the barriers that stakeholders outside of Europe are likely to face in terms of relying on mandatory human rights due diligence laws. So while there's room to be optimistic, I would urge us to be cautiously optimistic. And this means that we have to acknowledge that the law is good on paper, but the true test of its ability to change the reality on the ground will depend on how the laws are transposed and how the laws are implemented in reality. So think about these stakeholders that I've already referenced who are outside of Europe, and maybe even to make it more personal. If you go to the supermarket today and buy a banana, check the sign and see where that banana that you're eating in Luxembourg comes from. Or if you have an item of clothing, check the label and see where the item of clothing comes from. In today's world of very interconnected global value chains, companies operating or based in Europe have suppliers all around the world. These are the people that I'm thinking about when I mention global South stakeholders. Do these people even know that there's a law like the CSDDD currently being, transposed in Luxembourg that could potentially change their lives? Do these people have the technical and logistical capacity to contribute to due diligence processes, right? Article 13 says, yes, we're giving you the right to be a part of due diligence. Is it as simple as saying that? Will these people be able, the stakeholders that we're thinking about outside of Europe, will they be able to actively take part of these due diligence processes? An example from the supervisory authority. BAFA has already set up an online portal where stakeholders, wherever in the world they are, can complain about German companies. The form is online. Very simple, very accessible form. Go online, fill it in. You can fill it in anonymously and raise your complaints. I come from a country where not everyone has internet, right? Not everyone speaks English. Not everyone speaks French or German or all the languages that are there for purposes of this kind of complaint mechanism. So even when you say that there's a supervisory authority and it has the power to listen to substantiated concerns, what does that mean for a right holder on the ground who wants to use this particular provision? And then, of course, think about bringing a case to court. Even for you today, if something happened, when you're living here, I hope this doesn't happen, but if someone hits your car and you decide to take them to court, it's timely, it's annoying, it's expensive. Now imagine how much worse that is when you're a stakeholder outside of Europe. You don't have the money, you don't have the know-how, you don't know the language. There are so many barriers that would stand between you and the civil liability that has been promised to you in Article 29 of the EU Due Diligence Directive. So because I don't have time, I'll just very quickly conclude by using the KIK example. And KIK, I'm hoping that many of you are familiar with the KIK case. KIK is a German company, and in 2012, one of its suppliers in Pakistan had a huge fire that resulted into a tragedy. Very many people killed, very many people injured. Now, the victims of the KIK tragedy tried to seek justice within the context of German law. They were unsuccessful because at the time there was no Lieferkettengesetz. But I would want us to reimagine this same case being brought today within the context of the Lieferkettengesetz or within the context of the law such as the CSDDD. Certainly, these laws have the capability to change the terms of play, right? Because I believe that if this kind of a case was to make it before a court, then there's very likely that the court would be able to say that, okay, the company has violated its due diligence obligations and has breached human rights and environmental rights of the affected persons. But again, with the Kik case, there's a lot of evidence that the Pakistani stakeholders in question were not able to bring all of these complaints on their own. It took the very deliberate and active labor of organizations such as the European, the ECCHR, the European Constitutional and Human Rights Center in Berlin, which is an NGO in Germany, as well as Medico, another body that helped really the stakeholders to be able to bring their claims all the way from Pakistan to Germany. And to date, they're still fighting, trying to go before BAFA to show that even all these years later, violations still continue in the factories of Kik, this German company. So as you can hear, my timer went off, and I'll take 1 minute just to conclude my discussion because I was asked to keep time. What next for transposition, and what next for implementation of due diligence laws? I think that we have to find ways to be able to perhaps aim for the highest possible standards, and Jean-Louis and all the other speakers have said this as well. It's possible because the EU directive actually is a minimum harmonization rule. So member states have the right, if they want to impose higher standards within the context of their national laws. So it could be possible for Luxembourg, for example, to come up with a law where they decide to wholly include even the downstream actors in the financial sector. It would be possible even for Luxembourg to decide, okay, the civil liability in our law, we're also going to include a provision on reversal of the burden of proof, so that we make it easier for Global South stakeholders to actually be able to stand a chance of winning these civil cases. In addition, and Bashak mentioned this, we're expecting guidelines from the European Commission. Potentially the guidelines may be an important and useful tool to help clarify exactly what due diligence is, how it should be done, how companies should engage with stakeholders, and so on and so forth, so that all of the promises of the law that we have on paper can actually translate into reality. Beyond that, I think that there is really a need for very concerted and deliberate building of transnational solidarity networks between stakeholders in the global north and stakeholders in the global south. And here I'm talking to Jean-Louis and Pascal and all the members of the initiative, right? Your work is cut out for you over the next couple of years. Now that we have the law, you have to build capacity. You have to forge networks with stakeholders outside of Europe so that you can help these stakeholders be able to make use of these laws. Without you, the laws may remain on paper but not change the realities on the ground. And of course, we also need to think about raising awareness. We need to have capacity building of Global South stakeholders. Because at the end of the day, like I started by mentioning, the EU CSDDD may be a game changer, but for who? If we want it to be a game changer for Global South stakeholders and other stakeholders outside of Europe, there's a lot more that needs to be done. Thank you very much.